we're not gonna have the situation where we have everybody in this room. We got the funders, we have worker leaders, organizers, immigrant rights leaders, legal advocates, policy advocates, academics. We have them all in the same rooms. Let's take advantage of this opportunity to ask each other questions of the great presentations and also comments you want to share with the group. So it's open to yes, Josh.
So the operating instruction is an internal guidance from the former INS that DHS continues to abide by, that requires before the government engages in an immigration enforcement action, they have to go through certain steps if there is an existing labor dispute to ensure that the government is not interfering with that labor dispute. And so essentially what happened here, we were negotiating a contract when the audit first started. So we tried that. And we also not only notified DHS directly, but we also demanded that the employer, when they met with DHS, to let them know that this was happening and that they were interfering with workers' rights. I mean, during the commencement of the audit and during the contract negotiations, there were negotiators who were fired, the workers went on strike. I mean, these were legitimate labor disputes. But DHS pretty much said that this was something that had been approved higher up, outside of local agency. Then after that, when we filed our unfair labor practice charges, we filed the E-Verify charge, we filed a charge just generally trying to state that there's a labor dispute going on and the employer is not negotiating with us regarding the audit. But the reality was that the employer was negotiating with us. But we tried many, and we would notify DHS each time we had existing charges. We even asked the board agent assigned to our case to talk to DHS, but it basically didn't work. We were told this was approved higher up, which is what the OI requires, that they get approval from someone higher up to continue the.
Yes, so we, in the context of the facilities we've been really active in, we haven't seen audits with workers that are active with us. We have had threats. Where we've been able to work with the DOL is looking at the possibility of U visas for some of the workers. There's the biggest Walmart warehouse in the region, operated by Schneider National, in right near where Ruben works in Eastvale, California. There was a group of workers that were basically, intimidated away from testifying to the DLSC. And so we're looking at possibly obstruction of justice and witness tampering. So that's the process that we're looking at. But we do know that there have been audits with workers that have been organizing that haven't been involved with an organization. We've tried to lawyer up as much as we can and tried to really, build as much of a presence with the company before they can do anything. Make sure that the state agencies are watching. Make sure that that every agency knows what's going on as early as possible, and we feel like that puts them on their heels. But when workers have, gotten together on their own, they just, either get rid of the staffing agency or they'll call ICE in, and we've heard about that and seen that happen. But so hopefully, the resources that we've been able to draw from a lot of you guys has helped that.
I think with the car wash campaign, it has been like a different level. So I think even though we have like a great leader in the deal at the top, like Hilda Solis, the regions, or like it really comes down to how each of the regions works with the advocates. So in our experience, it's been difficult to work with DOL, and it's a challenge because a lot of the times they're the ones who decide where they're going to investigate or move forward with any type of investigation, or actually filing or referencing out the actual case. And when you're doing campaigns, like a lot of these are very strategic targets. So we deal with that. That's a challenge. But we do see the importance of course, having a good open communication system with them. And now, more recently in our efforts, really pushing the agencies to speak to themselves, the DLSC and the DOL, about you know, some of these open investigations and how they could better work together on these two. And then also, of course, us in the mix of that. But we've also had success stories on the U visas as well, not through DOL, but through the city attorney. And although there was some challenges, of course, of also educating the city attorney about what are some of the categories that qualify workers for U visas. You know, we've one of our biggest fights earlier on, way before I was here, and Chloe and Justin in the back probably know more of the details, so ask them. But with the Perian case, you know, we were able to, after the criminal charges were filed and they were found to be guilty, it opened the window for a U visa certification for 6 of 7 of the workers that were big leaders in that fight, and many of them have already had their biometrics appointments and are way on their way on getting those. But I think the other highlighter where the intersection comes with immigrant rights and workers' rights, and we're seeing it now in many campaigns, is through the deferred action stuff as well, where it really opens up a whole other window of using this opportunity to get young workers to adjust status or at least get the deferred action. And I think that for the labor movement too, or the workers' rights campaigns too, becomes a challenge too, because it's a very thin line between how do you have this conversation about somebody's legal status and how do you document it? How do you help them get the right help without putting it on paper? And so I think for all those interactions, there's like, they're good tensions. We're really learning along the way.
I think for us, I believe the DOL ICE memo was revised in December of 2011 last year. And so prior to that, it did not include the specific language with respect to bargaining contracts as part of a labor dispute on the ICE DOL memo. So since then, now for all employers, we notify DOL that we're starting to enter contract negotiations so that they know that's there, so that in the future we can invoke that memo with DOL. But unfortunately, Pacific Steel happened before the memo was revised. And in terms of U visa, I just want to point out that Kevin Kish is working with warehouse workers on the litigation with Schneider and the U visas.
Okay. Any other questions or comments? Yeah, in the back, way in the back.
Comprehension immigration reform work or partial immigration reform for your labor organizing efforts. Does that make sense?
I think this is something I've been thinking a lot about, and I think if we learn from sort of our opponents that are the very conservative, radical conservatives that are fighting us constantly, what we have seen is they're going state by state, county by county, municipality by municipality, and I think that it has been a lesson learned. I feel that right now, even in the local fights, whatever we can take from the local fights to build up those numbers, it's really a good strategy to build momentum. And earlier on today, we had the breakout session about E-Verify, and we had some brilliant ideas come out of that conversation about what we just learned through the DREAM students and the young undocumented student leaders in the country, where they went through the administrative piece. And I'm talking about we, but I was part of that effort, and I feel like I've been itching to use some of those lessons learned for workers' rights, because my first exposure to organizing was with workers. And so, let's look at the different alternatives, and if we cannot win the 15 million number to get adjusted in this country all at once, then we must, and it's our duty to think of other strategies to build that number up. And it's not the ideal, but we gotta be smart about it.
Does anybody else want to comment on that question? Okay. Another.
And just actually, Kevin, I want to ask you if you can explain what U visas are, because not everybody may know that. And please, if you can use the mics, because it is being recorded, so it can get captured.
U visas.
Are U visas, Kevin?
Well, Maria Elena. U visas are visas that are available to victims of certain types of crimes that are listed in federal law, and that do include, in addition to things like rape and assault, witness tampering and obstruction of justice, and the types of crimes that we more frequently see in workplaces where there's retaliation, for example. And Eunice, as you were talking, one of the things is we have to advocate for a different definition of harm, right? It's not just physical assault and bruises that you can record in a hospital, and somehow we have to get that message across to the agency as well. And Eunice and Nelp are doing fantastic work collecting this information that helps all of us then be able to file applications that are ultimately successful, because it's not actually, as it's turning out, that difficult to get past the first hurdle if there has been severe retaliation in a workplace. And it's the second hurdle that's proving difficult. I had a question for the panelists and for the entire room about the subcontracting schemes that Shahryar was talking about. And we do in California. You mentioned Labor Code Section 2810, which for those in the room who don't know, is the statute that imposes liability down the chain when a contractor knew or should have known that the contracts they were entering into weren't enough to provide for minimum wage and minimum workplace standards. And it's a great statute, but the fact of the matter is that very few cases have ever been filed under it. It covers certain industries like garment and construction, farm working, and hopefully soon warehousing. But my question is, this is a system that we are seeing more and more frequently. It doesn't look like it's going anywhere, and in fact it looks like it's expanding. So are there non-legal strategies that you have found to be successful, or strategies of any kind, or that might be successful in compelling contractors to take responsibility for what's going on in the industries that they control without the benefit of a statute like 2810 or similar legal approaches?
So our approach is looking at Walmart, right? Our approach is looking at Walmart, which has already established a code of ethics and a code of standards for their contractors, including contractors of supply chain systems and goods movement. So they have this massive 120-page document that they have on their website, which says this is what our suppliers are allowed to do. This is what they're not allowed to do. They're not allowed to break the law. They have very specific standards in terms of child labor, in terms of health and safety, in terms of the right to organize. Actually, if you read it, you're like, wow, this is pretty good. It was developed a couple of years ago in direct response to the anti-sweatshop movement, focused primarily on the way that their brand was being brought down by the conditions in Asia, but it applies directly to workers in the United States as well, and they're not holding to it. We know that. We have a litany of violations that we've been able to identify just because we've been focused, but there's a huge amount of other 100% or even much less Walmart operators that don't follow the law. And so what we're doing is calling on Walmart to actually hold to their own statements and to agree to make sure that they do cover, and audit and look at these facilities.